Hello everyone, welcome to Jamaica 411. Thank you so much for stopping by, keeping me company as usual. If you're here for the first time, welcome. Please subscribe, share the video, give the video a thumbs up as well, and you're welcome to leave your comments in the comment section. To my subscribers and regular viewers, welcome back. So nice to have you. And I appreciate you a great deal. So, you know the ropes. Go ahead, please. Give the video a thumbs up from now because, as I get into this riveting affidavit, which was filed by Andrew Holness in the Supreme Court, you don't want to move and go anywhere at all. All right. And of course, I thank you in advance. Great. So, preliminaries out of the way. Let's now get down to business. So I'm bringing you now a segment of Andrew Holness's affidavit, which was filed, as I said before, by his attorneys. And this segment begins at paragraph 34. I'm not going to go back over what was there before. I know your time is very valuable, but for persons who have not seen part one, I urge you to go ahead and watch part one before you watch this one so you can get a full understanding of what it is that Holness is asking the court for and why. Now, we reached a critical point in the affidavit. We were at the notice of interview, judge's rule document, which was sent to Andrew Holness on the 18th of August 2023. This was the day after the journalist asked him about persons in his government, on the government side, who may have been investigated for illicit enrichment. He said he didn't know of any. He had asked and he didn't know of any. Now, even though he was being investigated, they did not tell him what it was they were investigating him for. Yes, when they informed him that he had left off his parents' 3 accounts and the account for the constituent, he would have known that they were investigating him for making a false statement on his declaration by omission. What they did not tell him, though, with the questions that they were asking, was that they were investigating him for illicit enrichment. Until the day after he said what he said on the media, they sent him a notice of interview, judge's rules document. And that was for the meeting that they had already arranged for the 31st of August. So they were giving him notice of what the meeting would have been about. And that is when they mentioned that he was being investigated for illicit enrichment. All right, so that's the background. So let us now go to paragraph 34 and see what it says. However, I'm going to read from paragraph 33. So it says that I observed, however, this is Andrew Holness speaking in his affidavit, that I observed, however, that apart from the statement in the notice about illicit enrichment at the top of the notice, I was not given a figure that required explanation, and I was not asked about my income and liabilities as set out in the declaration. I was advised by my attorneys at law and do verily believe that I should have been told the sum that is considered disproportionate. So they are arguing that when the notice came to him, telling him of what the meeting will be about, what the interview will be about, that he was being investigated for illicit enrichment, they did not actually say what the figure was that they were investigating, which of course we know as 1.9 million, which they said was above his net worth and therefore required them to do some investigations. So he's saying they never told him the figure. Can you imagine? So he clearly was not given an opportunity to look at those figures, go to his accountants, and see if they can sort it out. In my view, that would only be fair. Don't you agree? So to continue, it was against this background that my attorney spoke to the second respondent, Stephenson, on the 29th of August 2023 and confirmed the discussions on the 30th of August 2023, the concerns were A. The scope of the investigation, B. The obvious error in the conflation of corporate and personal assets. Wow. C. That there is no clear statement of the basis for the conclusion that my assets were disproportionate to my lawful income as required by Section 14(5)(a) of the Corruption Prevention Act. If you're going to say that somebody's income is disproportionate to their assets, you must show something. There must be some formula by which you came to that conclusion. There must be something that is set prior to you going to examine any of the statutory declarations coming in, whether from the parliamentarian or the public service, right? You must have some ratio, something that says, okay, when I see this, this is a red flag. They have no such thing apparently, and they're claiming that the net worth of 1.9 million is disproportionate to his lawful income. And what was his lawful income according to them? 6.7 million, his salary. They did not take into account, even though they went and combined the assets of the company with his assets in his name, they did not combine the income that the company received in dividends, interest, and so on, which would have brought it to $13.2 million. But anyway, let me continue. At subparagraph D, he said, the fact that there is no statement that identifies the assets owned by me by classification and or value, or statement or evidence that sets out the assets or the amount by which my assets disproportionately exceed my lawful earnings, the failure to afford me with the precise terms, nature, and basis of the allegations against me to enable me to respond accurately to the allegations, and the statement that I am being treated as a suspect. And then, of course, the copy of the letter was submitted as an exhibit marked AH11. So those were the concerns which was expressed to the IC prior to the meeting on August 31. But let us move on to paragraph 35. Now, Andrew Holness said here, it is important to understand how the error arose in terms of the conflation of assets as stated above. In 2020, consequent on public concerns being raised that I was a shareholder and director of ADMAT Incorporated, an international business company incorporated in St. Lucia, I made the decision to wind up ADMAT and replace it with a company incorporated in Jamaica. Accordingly, ADMAT's assets were transferred to Imperium. The process of transferring assets from ADMAT Incorporated and from me personally to Imperium was completed in 2021. Remember, that is the statutory declaration that they have not yet certified, and they are supposed to be, or were supposed to be, investigating. For the avoidance of doubt, this transfer of assets related to existing assets that were owned either by me personally or ADMAT, and these assets would have been previously reported in my statutory declarations for the period years that were certified by the first and or the third respondents. So what he's saying is, these guys have certified the statutory declarations that had declared these assets. Nothing has changed, nothing was increased. It's the same assets. He's just moving it from ADMAT to Imperium and from himself to Imperium. Nothing has changed, is what he's saying. My residence is owned by the second applicant, which is Imperium. As public concerns were raised that I had my assets in a tax-favorable jurisdiction, I became concerned about their views from a transparency perspective. Accordingly, I formed the second applicant, Imperium, and brought the assets into the jurisdiction from ADMAT as explained. In relation to that, I incorrectly attributed the value of the house as shareholder investment for the 12-month period ending 31st of December 2021. However, I was advised by my attorneys at law and do verily believe that it is not correct, as it made it appear that it was new money when it was not. So because he opened a new company and he went and classified the house, that is the Shenstone property, the value of it, as shareholder investments. It gave the impression that this is a new business that came in with new assets. You understand? Okay, great. So this is the day of the meeting now, paragraph 36. On the 31st of August 2023, I attended a meeting at the office of the Prime Minister with the second respondent, Stephenson, and his team, including Stephanie Fiddler Blake, a forensic accountant, and two other officers of the third respondent, that's the commission, who appear to be responsible for the secure recording of the proceedings. So the forensic person was there, the forensic accountant. Interesting. I was accompanied by my attorneys at law, Georgia Gibson Henley, KC, and Stephanie Williams. It was already understood and agreed that I would not answer any questions at that meeting, as the questions would have been put in writing. The meeting was to formally commence the investigation. Remember, it was a what they call it? A judge's rule. So it was a caution. The judge's rule, KD Knight explained to us, is a caution. Like in America where they read your rights. Anything you say may be used against you in a court of law or something. Yes, that is our version of it. It's called the judge's rule. So he went on to say, my attorney also raised the issue of the incorrect completion of the form and whether there was scope for correcting the form. This was in part because the areas for concern for the investigation substantially related to juristic persons, the second to fourth applicants, and Estate Bridge. These are the companies. The second defendant, I think is respondent, that would be the, what's his name? Stephenson, also stated that there were some transactions to the value of over $1 billion, and they are trying to account for approximately $350 million. My attorney and I expressed spontaneous shock at this assertion, as we attended the meeting to deal with 2021 and there was no such figure on the 2021 declaration or financial statements. You weren't shocked too? You think you have, 200 and something million? And them I come tell you about transactions up to $1 billion. I couldn't feel account them. They look pan. I know your statutory declaration. I must say my account. Lord, I can't imagine how they were shocked. Can you imagine? My goodness gracious me. Let me continue. After this expression of shock, the second respondent, who is of course the investigator, Kevon Stephenson, and or Mrs. Fiddler Blake, that is the forensic expert they brought in, clarified that this was not for 2021, but based on bank statements for 2021 up to June 2023. My attorneys and I were relieved, of course, who wouldn't be? We pointed out that they were not comparing apples and apples, so they should tell us a figure that relates to 2021. It was agreed that the written questions would come later, based on the representation by my attorneys about the reason for the sum of $350 million and how it was arrived at by reference to an incorrect period. I expected that this would be corrected when the additional questions came, particularly the reference to 2022 and 2023. However, when the additional questions came, they still contained questions about a period beyond 2021, and they of course exhibited the email of questions, which was sent to them by the Director of Investigation as evidence. He said at paragraph 37, by letter dated the 11th September 2023, the second respondent, Stephenson, responded to our concerns as set out in our letter of the 30th of August 2023 and the meeting of the 31st of August 2023. His response confirmed the area of concern as stated above as being my dealings with the companies Imperium Holdings Limited, Positive Media, Estate Bridge Development Limited, or Estate Bridge Holdings Limited. He agreed that the companies are juristic persons and therefore separate from me. Notwithstanding, there are concerns around the purpose for which the reference companies were established and their use. That's what the investigator wrote back to them and said. And they're quoting him. In relation to the procedural matters, he stated that he had indeed provided particulars of the assets, including the value of the assets that require explanation, by way of the notice dated the 18th August 2023, see Appendix 1 to 23, with the understanding that more specific questions would be asked during the course of the interview, and he exhibited that letter at AH 13. As this letter did not address the objection raised on my behalf regarding the subject matter of the investigation or the provision of the disproportionate figure that I was required to explain, I asked my attorneys at law to write to the second respondent, again, which is Stephenson. Accordingly, by letter dated 27th of September 2023, my attorneys responded to the second respondent, Stephenson, reiterating our objection to the investigation. Notwithstanding our objections and without prejudice to my rights, the answers to the questions were provided in this same letter as based on the terms of Section 14(5). I was at risk of committing an offense if I did not respond at all, even though I understood from the objections on my behalf that the threshold for conducting an illicit enrichment investigation was not met. Nevertheless, at all times while answering, I maintained my objection and indicated that the answers were being provided without prejudice to my rights to challenge the said procedure. However, in light of the delay in the certification of my statutory declarations, the public interest in the completion of the process, my sensitive position as Prime Minister, I thought that it would be in the best interest for the answers to be provided so that the process can be resolved in the fastest time possible. However, in instances where the questions were outside of the scope, that is beyond the 2021 period, I indicated same and limited my responses to the 2021 period under review. And he exhibited the letter he's referring to as and mark it as AH 14 evidence. That by letter of the 25th of October 2023, my attorneys received another letter with additional questions for clarification, and they're exhibiting that letter as evidence marked AH 15. That along with my attorneys at law, I reviewed the additional questions. I noticed that the period for the questions was expanded to 2022 and the 2023 period. I made this observation as it was different from what was communicated to me on the 18th of August 2023. This was of particular concern as at this time the statutory declaration for 2023 was not due for submission. So what were they looking at? This was 2023, and the 2023 declaration would not have been due until 2024. So what were they talking about? Anyway, let me continue. Accordingly, By letter dated the 4th of December 2023, my attorneys responded and objected again to the procedure and further confirmed that questions for 2022 and 2023 are out of scope. My without prejudice responses were provided to the second respondent, Stephenson, and they exhibited the response that they made to him, and it was marked AH16 as evidence. At Section 1, Andrew Holness stated, by letter dated the 17th of December 2023, the second respondent, Stephenson, responded confirming receipt of responses and stated that his inquiry into allegations of illicit enrichment cannot be limited to a particular year. And then he exhibited this particular letter that he received from Stephenson. My attorneys responded by a letter dated the 3rd of January 2024. All right, we're coming up to current times now. Reiterating that the investigation is out of scope, alleging confirmation bias and complaining about delay. I was reliably informed by my attorneys at law that confirmation bias means that the respondents arrived at a conclusion without evidence and were looking for facts to prove it. Wow, that's a hell of an accusation, that. My attorneys also expressed concern about the delay in dealing with the matter, and the letter was exhibited as evidence, AH18. So you can imagine that this matter of him being able to expand outside of the referred year 2021 is something that the judges will be looking at, and it will be very, very important for the judge to make a declaration on that, whether or not, when looking into illicit enrichment, he is confined by the year that was referred to him, or whether he should have gone back to the commissioners and say, look, I need more years to look at illicit enrichment. 2021 is not enough. Was that the procedure? Was he supposed to have gone back and have the referral amended to include other years, which will now allow him to examine the other years in question? That seems to be what is at play here. This is a very interesting conversation, backward and forward, between the attorney as well as Stephenson. What I find interesting is that Stephenson didn't have his own attorney. I'm sure the Integrity Commission has, or ought to have, their own internal legal department. Well, I don't know, but he was there talking to this very experienced attorney who is there telling him the law, and he evidently was advising himself about the law. On the 2nd of February 2024, I was advised by my attorneys at law, and do verily believe, that there was a meeting at the office of the third respondent with my attorneys, Georgia Gibson Henlin, KC, and Stephanie Williams, and the second respondent. This meeting, he said, was held at the third respondent, that's the commission, the Integrity Commission, between his two attorneys and Stephenson. At this meeting, the second respondent, Stephenson, explained the cause of the delay as being related to requests they made of third parties and our failure to respond to questions related to 2022 and 2023 that my attorney said were outside the scope of the referral. You recall that he had actually written in his report that Holness had refused to answer questions, and that's the reason why he could not draw any conclusion as to the illicit enrichment. You remember that? But that was not the truth. The man didn't refuse. It was the attorney that was saying that this thing is out of the scope of the referral. He did not consult with his own in-house attorney. He must have the in-house attorney there, right? He did not consult with the commissioners, with two eminent judges as commissioners, to find out whether or not they have a point, or to get their approval to expand the scope to these to these additional years. One of them not even due yet. And then when you consider that he also recommended that the FID should look into the matter. What can this be? This look like to me? To me, it looked like malice. The attorney saying, look, you are out of scope. It's 2021. You must look at you says illicit enrichment. You need to find the evidence for illicit enrichment within the year and within the declarations. Or if you do investigation and find out some other things, do your investigation within that scope, right? And he's going to write in his report that the declarant, Andrew Holness, refused to answer the question. So this is the reason why I could not complete my investigation into illicit enrichment. And I recommended that it should go over to the FID and let them complete it. This is not an investigation. This look away. Don't you agree? Or you disagree? If you disagree, put it in the comment section and let me hear what you think about it. This sounds all right to me. This sounds very strange. Anyhow, let me continue. I am advised by my attorneys at law and do verily believe that the second respondent pointed out, this is Stephenson, pointed out that the outcome of his investigation does not have to be charges. It can also constitute recommendations. Charges? Oh, yes, and he did make recommendations, didn't he? Didn't he recommend that his report should be passed over to the FID for further investigation, further delaying the certification of the man's declarations? But let me continue. My attorneys pointed out as well that based on the nature of the supposed investigation, may I agree with her? This is really a supposed investigation. As being one for illicit enrichment, it cannot be based on a date after the allegation was made. This is serious. The allegation was made that illicit enrichment occurred in 2021. And at least in 2022, he arrived at the 1.9 million, right? It was in 2021 that they arrived at the 4.4 million. And that seems to be what the attorney is basing her comments on, her advice to her client on, because that was what the referral was referring to, the 2021 declaration and the 4.4 million apparent increase in his net assets. And we had discovered here at Jamaica 411, you and I, that 4.4 million that the commission was referring to actually was inflated when they added his parents' $4.5 million to his statutory declarations, because his name appeared on their bank accounts. So they had to add it in. But what they should have done is taken it out, because the money that's in those accounts was not contributed by him and any of his income. So to put it in there would have inflated and give a wrong result. So that is what the attorney is focused on. But the investigator is focusing on the 2022 declaration, where he arrived at an increase in assets above his lawful income, according to them, of 1.9 million. You're following what is going on here? And the lawyer is saying you can't do that. You're not a referral for that. Deal with what you refer to. And he's saying, no, I can't do it. You understand? I can't go outside of the scope. How am I going to investigate illicit enrichment for 1 year? I have to go outside, right? And this is what the tug of war was between the investigator and the attorney, till the attorney reached a stage where the attorney referred to the investigation as a supposed investigation. So even she was coming to the conclusion, thinking as a one yes or two, as we are, aren't we? Anyhow, let me continue. It says here, in addition, they pointed out that the 2022 declaration was not referred for investigation. You see, that's what the attorney is contending. And we saw it for ourselves in our previous videos, that the commission spoke about the 4.4 million and specifically said for the year ended December 31, 2021. So let me continue. My attorneys at law further advised that they had no instructions on the 2022 declaration. Same thing we're saying at Jamaica 4112, aren't we? Great. Nevertheless, my attorneys requested that the said questions be put in writing so that a decision could be made on whether to respond. At paragraph 44, by letter dated 8th February 2024, this is in the middle of the local government election, you remember? That was due on the 26th of February. Now we know why he was so distracted and so subdued, right? He had all these troubles on his mind. So by letter dated the 8th February 2024, the second respondent, Stephenson, made his formal request and also sought to explain the slow pace of inquiry and enclosed questions for period prior to, Lord have mercy, compound the whole thing, and enclosed questions for period prior to 2021 and up to 2022. By a further letter dated the 12th of February 2024, he stated the timeline for response. They might tell him when them for response or else. Imagine that. The people might object and say, listen, you only have scope for 2021. And the man go compound the matter. In the middle of the local government election, go send the man a letter and his attorney. I tell him now that they want answers to questions from prior to 2021 and up to 2022. This is when he had gone all the way back to 2019. You remember that? Yes. So it's all them excitement did I go on in the background. Anyway, Andrew Holness and his attorney exhibited the letters that he had sent them and marked as AH 19 and 20 respectively evidence. So at paragraph 45, by letter of the 12th of February 2024, the same day, my attorneys responded that our agreement to provide the information is based on his indication that the investigation would also cover the investigation of the 2022 statutory declaration, that I have been reliably informed by my attorneys at law and do verily believe that they advised the second respondent, Stephenson, that they were not aware that it was referred, and in any event, if that was the intention, it should have been stated given the terms of the statute, being section 14.5 of the Corruption Prevention Act. My attorneys continued to preserve my rights on my behalf in the meeting and confirmed in the said letter, and they exhibit that letter as well. So this man was just being obstinate. He was not consulting with any attorney. He was advising himself. And it seems to me, just by reading this, if it go, like how them say go, this investigation, as well as the report that emanated from it, I can well imagine what the judges at the Supreme Court were saying about it. Right? I mean, this is just unbelievable. But there is more, so let me continue. At paragraph 46, Andrew Holness stated, in light of my attorney's concern that the investigation had now moved to 2022 declaration, even though it was not referred by the commissioners, I caused them to request information from the first respondent, that is Mr. Beresford now, the Director of Information and Complaints, whether he had commenced his examination of the 2022 declaration. By email of the 16th of February 2024, the first respondent, Mr. Beresford, confirmed that he had not commenced the examination of the 2022 declaration because he is awaiting the outcome of the investigation of the 2021 declaration. So what the hell is Stephenson investigating when that don't even reach to him yet? Look here, for the 2022 declaration to be looked into, that has to be communicated to Stephenson, not only in a referral, but he must also have the physical document before him. And Beresford is saying, no refer not like that to him. Me not start look upon that yet. Me wait upon him to finish look upon 2021. So Beresford himself think that the man over there examine and investigate the 2021 declaration. So you can see there's no doubt as to what Beresford, had recommended and referred to the commissioner. He referred the matter of the 2021 statutory declaration, and he's waiting on the outcome. And there is Stephenson doing his own thing and a frolic of his own. Some serious investigation needs to go on. They need to look into the background of that man Stephenson and see where him and Holness ever buck up. Did they go to university together? Did they go to high school together? Did they go to picnic school together? Did they live in the same area? Did they date the same girlfriends? They need to go and do some investigation. There is something seriously wrong here. And I agree with Henlin that this is a supposed investigation. Something that look right as a man. It's strange. Tell me if you agree or disagree. Put it in the comment section, please. So, of course, the email correspondence is being exhibited as evidence at AH 22. By letter of the 29th February 2024, the second respondent, Stephenson, reiterated that he is not limited to the 2021 period and that he required the responses to the 2022. Requested answers to additional questions and indicated that he is unable to say why the statutory declaration has not been certified, as it is not a matter within his remit, and they exhibited that letter. So, even though, now that I come to think of it, even though Beresford said that he has not started the examination of the statutory declaration for 2022, the question is, how did Stephenson get his hand on it? Because you recall in the report, you saw where he was making references to what it was that Holness had declared on his 2022 statutory declaration. Don't you recall that? Yes, that's how he managed to work out the 1.9 million. So if Beresford is saying, me not even start look on that yet, how did Stephenson get it? Who sent it to him? That must be Beresford. So, I mean, this thing is sting to high heaven, you know, my peeps. Sting to high heaven. But let me continue. So, 18 days later, by letter dated the 18th of March 2024, we requested an extension of time to respond. Further, by letter dated the 25th of March 2024, my attorneys reiterated our objection to the expansion of the scope of the investigation to include 2022 and 2023 in circumstances where there were not referred to the second respondent, Stephenson, for investigation. And they submitted for as exhibit a copy of the letters that they had sent to him, the two letters. By letter dated the 27th of May 2024, the second respondent, Stephenson, enclosed further questions requesting for the first time income and expenditure statement, May of 2024, for the period ending December 2021 and 2022, information concerning the NFE bond issue, properties owned by Estate Bridge. And they, of course, exhibited a copy of that letter that was received. They are going on to Beryl, so I think this is a good place to pause. So we'll continue tomorrow at paragraph 50. So thanks for joining me. Please remember to share, like, subscribe, leave your comments. Until next time, take good care of yourselves and walk good.